How do I want to start it, John?
Uh, that's a good question. Well, I guess we should introduce, well, I guess everyone watching this on your site will know who you are, but we should introduce ourselves, I suppose. And then I guess the idea is to kind of talk about a little bit about the legal landscape of the way, um, dancer compensation works in different areas, different parts of the country, and how it might be evolving. And then, kind of what the options are for people going forward.
Great. So let's start with you introducing yourself to everyone who doesn't know
Sure.
you. You are.
Yeah, sure. My name's John Mays. I'm a lawyer at Chesin Walbert in Atlanta. I've been practicing wage and hour law for almost 10 years now, which I kind of can't believe. Um, and I've handled, I do a lot of collective action work, particularly overtime litigation. I've handled cases for dancers around Atlanta um, for several years. Most of those have sort of wrapped up now, but that was kind of an area where we had a bunch of cases a few years ago. So I'm pretty familiar with both the legal issues with respect to classifications and wages for dancers, but also just the way that I guess litigation kind of plays out and how it affects people. So hopefully I can answer whatever questions you might have, and without providing obviously any like specific legal advice, but uh, but I'll try to answer whatever questions you might have, and hopefully it'll be useful for people to check out.
So I want to start with the very, very basics of this, because I think a lot of
Hmm.
the words you just used, classification, wage and hour, litigation,
Hmm.
class action, all of those are, I think to an attorney, they're the ABCs. For someone
Sure.
walking into the adult entertainment industry, let's think about someone who's maybe between 18 and 20, who's maybe this is their first job ever, and they're
Yeah.
not super familiar with the terms or even how they're getting paid. In our industry, a lot of the time you show up, right? Maybe you don't even clock in, you just show up, you get cash,
Hmm.
and then you get out. And maybe you're
Right.
not as familiar with what all the different ways that you can be hired. So let's talk about, I want to maybe have you introduce the three major ways that entertainers are hired in the US, which usually looks like 1099, W-2, and then you have like K-1 company owner situation.
Hmm.
So
Yeah.
let's start from the most, I think the most widespread way that we're hired is independent contractors. Which of those three is a
Yeah, so on, yeah, 1099. So for 1099 or contractors, the idea is that the when you get paid, you get paid, whatever the full amount is that you've negotiated or the club is offering. They don't withhold any taxes, and that means you're responsible for paying taxes later on that money, which is a whole nother kind of issue. But yeah, I mean, contractors ordinarily are, um, you know, uh, well, traditionally they were hired to do kind of like short-term projects for a company that were maybe outside of that company's normal like area of service. But there are certain industries where both the employers and the employees sometimes, at least initially, think that it can be a better way um, to to handle compensation.
So
So,
can you give me an
um,
example of
mhm,
something outside of the strip club industry where someone might be an independent contractor? What would be an example
sure.
of an independent
The,
contractor?
well, the classic independent contractor scenario would be, a general contractor gets hired to build a house, and he needs somebody to come in and do like, um, do like a custom set of cabinets that contractor that the general will then install in the house. And so he'll hire a carpenter on a contractor basis to do this one project, and then bring in um, that product and then install it in the house or something like that. Or um, sometimes companies might hire a contractor like a consultant to come into a company and maybe evaluate, are they meeting their advertising goals, and should they do something in a marketing campaign or something like that. So maybe it's a a 3 or 6 month project, and that person comes in and looks at what's going on and gives them advice and gets paid for that project. And so that's a situation where the person who's coming in is working for the company. They're doing something for them, but they're really not, ever going to be like a long-term employee that would, become part of the company permanently.
Got you. So they wouldn't receive
Mhm.
things like health benefits. They wouldn't necessarily be on.
Mhm. Yeah. And another important thing is that the contractor in those situations is providing kind of a special skill that is like, something that the company might not ordinarily be able to provide. So there's a special skill that's being provided. There's also, they typically use like their own tools and materials. They have their own sort of business going. So they often are, actively investing in themselves and in their work. And so they have an investment in things like their own marketing and their own business operations. That's that the company they might be doing the work for doesn't necessarily have any involvement in. So
Right.
those kinds of things sort of that's the sort of stuff that separates maybe an independent contractor from a traditional employee.
Can we talk a little bit about the authority structure for something like that? So, for example, if I
Yeah.
show up to make your cabinets,
Hmm.
what, can you tell me what to wear when I'm making your cabinets? Can you tell me when I show up to make your cabinets? How much control usually does an employer have over?
Yeah. Yeah, and even to take a step back on the control issue, the first question is always going to be, where's the work being done? So for the carpenter who shows up to put the cabinets in, or to make the cabinets rather, they might make the cabinets or construct them on site. They might make them at their shop and then bring them in. The first question is always going to be, where is the work happening? In the carpenter's scenario, like the carpenter probably make them at his own shop and then deliver those things to the contractor. So in that situation, they're working at their own location, um, probably free from a lot of active supervision from the general contractor. And so that's, again, that'd be a situation where it's more likely to be an independent contractor relationship. The degree of control is really important. I mean, that's like the most important factor is really how much direction and control the hiring party has over the party that it's employing. So um, for contractors, you would expect there might be sort of parameters for the service to be provided or for the product, but overall the actual execution of that would generally speaking be sort of free from active day-to-day supervision, and certainly usually done outside of the main employer's kind of premises.
Got you. So
Mhm.
that's sort of the structure of a 1099 contractor. And
Yeah,
now let's talk about an employee. What is the
yeah,
relationship between an employer and employee? Sort of all the same categories we just covered.
yeah. So um, it's in theory it's totally different. So the idea for employees ordinarily is that you show up and perform work for the employer's business at that place of business. That the employer is gonna pay the employee and withhold a certain, like from a tax perspective, withhold a certain set of taxes that employers are required to withhold. Paying into things like Social Security and Medicare, and actually making the employer's required contributions to those things. Um, Also, the employer is ordinarily going to provide the tools and implements and office space and the things that the employee needs to do the job. The employer is also going to have control over how the employee works, when the employee works. And unlike somebody who's say, okay, go make me a cabinet, that person can make it in the middle of the night, or they can make it early in the morning. It doesn't matter. But for an employer, they can specify when and where and how the employment's going to be performed. So um, in that sense, it's just totally different from a contractor relationship.
Mhm. And then the last category is I've only seen this at a few clubs, but there there are clubs where when you start to work there, you are framed as a member of a company. Basically, you get a tiny, tiny amount of shares in the larger company that you're working for, and you're theoretically renting space from them when you show up to work, and then
Hmm.
you get dividends every every quarter, which are usually a
Right.
very, very small amount of usually their sales in liquor.
Yeah. So that's a new one. It's interesting. It seems to me like that, I don't know, thinking about it from the company's perspective, that seems to me to be a little bit of a scary proposition, to be, giving essentially what amounts to a kind of partnership or ownership interest in a business. But yeah, I mean, I guess in theory, the idea of a K-1 tax form is, that applies to the partners or owners of a business. And so they report income sort of differently than your traditional like W-2 employee or 1099 employee. There's a whole different set of forms um, that owners fill out. But it's really, I mean, for sort of practical purposes, it's kind of it's really a tax distinction. Sorry, my phone is ringing. The um, you know, in terms of like what it means, and with respect to the things we're talking about with contractors or employees and the degree of control, for example, you know, it's it's really not um, it's really not a for this sort of in the world of employment law, it's really not like a legal category. It's more of like a tax classification. But I would say that if that's the situation, it seems to me there's a lot of stuff to think about if you're going to become part of a company and be paid out through that company. I mean, that seems to me to be an area where the advice of a CPA would be extremely important. And certainly finding out kind of what the real terms of that arrangement would be, because I think it would be, it'd sort of be contractual in nature. Um, so anyway, but I haven't had a lot of experience with that. That's one that, it's seems fraught with problems, to be honest. And so yeah, it doesn't strike me as very common, but it's also, I guess it's a possibility, um,
So this
but
sort of gets to the
certainly,
bottom of what's been going on in the last few years, right? Which
yeah,
sort of to be this legal arms race to figure out where dancers
mhm,
get boxed in. So for a very long time, dancers seem to be 1099 independent contractors with a lot of the things that came along with that, and then maybe with some things that shouldn't have come along with that, right? Like
mhm,
control over your workspace and when you show up and leave and what you do there
mhm,
and what you're not allowed to do.
yeah,
Um, and then this wave of lawsuits started happening where
mhm,
dancers who claimed that they were employees were banding together and suing clubs. So
yeah,
how did that process work? You know,
yeah.
you decide, okay,
So,
I'm not getting paid wages. What happens
mhm.
next?
Yeah, so well, I think these cases come up even, I mean, sometimes they come up just as a matter of I'm not being paid properly. Sometimes it's something's going on in the workplace that, is inappropriate or unfair. And so that's the moment, I think, when most of the dancers who get involved, get engaged in the legal system, sort of find out that um, there's a big difference between the protections that apply to employees and the protections that apply to independent contractors. So, um, for example, when and I think it's generally, sort of speaking broadly, it's generally true that in most cases that have been litigated on this issue, the courts that have looked at them have said, well, look, because the dancers are showing up at the club, which is owned by the employer, because they're being told, when to come in, or um, or what to do, and being given a list of rules and that sort of thing. We're given instructions about how to do particular things. In general, there's enough control that's happening at a an employer's place of business that it appears these folks are going to be employees and not truly contractors. Also, a lot of dancers like will work at the same club for a long time, and so it's, and even though there's in any employment scenario, there's always some people that come in and out, or short-term employment, there are, especially in Atlanta, in the cases that I've seen, a lot of the dancers work for some of these clubs for many, many years. It wasn't uncommon to see dancers that were at some of these clubs for 5, 10 years. And that's also, the permanency of the relationship is one that the courts would look at and say, hey, this is really an employment relationship. So I think, at what would happen is, whatever the issue was, whether it was wages or something else, once the realization was that, look, there's really no protection from employment laws if you're an independent contractor, dancers realized that, look, in order to recover unpaid wages, in order to enforce like anti-retaliation provisions of federal employment laws, they really have to make the argument that they're employees and not contractors. And so that has a couple of consequences, one of which is, yeah, sorry.
What does that mean? Anti-retaliation, what?
Oh, right, yeah. So, for example, if you engage in some kind of a protected activity, like you report that you got unpaid wages to your employer, or if you report, sexual harassment or discrimination of some kind, or file an EEOC charge, there's all kinds of things that you can do that are considered protected activity, and that means that your employer can't then turn around and fire you because you've done that. But those laws don't apply to contractors ordinarily. They're, this is really about an employment relationship.
So if you do those things, let's say you say, okay, this manager has been harassing me, or I've been paying to work for the last 4 weeks because it's been really slow, and I don't want to pay house fees anymore. Then the club could just let you go, and there was no protection around that. Like, you couldn't go to an employment board or to the government and say, hey, this is wrong, this is happening, because they'd say, I'm sorry, you're just a contractor, they're not actually employing you, so you're
right.
not.
Yeah, I mean, in theory, yeah. So, or that's at least what the clubs wanted the dancers to think. So while and this is one of the reasons why when you look at these cases, it almost doesn't matter that it might be that the case that the clubs want the dancers to be contractors, and the dancers might want to be contractors for some reason. But when these things happen and they get reported, the agencies and the courts that look at them almost always view these as employment relationships, because they sort of satisfy the legal test, but also there's no way for them to help anybody if they're not in an employment relationship. And so I think that when you go to EEOC to report something, or you go to Department of Labor, or you raise the issue directly with your boss or your manager, you're, whether you know it or not, you're kind of invoking the idea that you're an employee. And then and it turns out that if that's the case, which it is with most dancers, there are these legal protections that apply if your boss then turns around and does something like fire you or treat you unfairly.
So we go from this era of the 1099 contractor only, and then I think you alluded to this a little bit, but then we get into this land, this no man's land of, a lot of times what happens is you show up to a club, you will go through your audition process, and then you're given 2 forms, and one of them says you can be an employee, and the other says you can be a contractor, and you get to pick, right? Yeah. In cases where that is the option, does it sort of end up the same way? Like, does that change whether you want to be a contractor or not? Does that really affect whether you are in reality?
Yeah, that's a good question. So it is technically a factor that, I mean, if there is a contract or an agreement between the parties, it is technically speaking going to be a factor that a court is going to look at in making a determination, but it's actually like one of the least important and often disregarded. And in fact, in even all the early dancer cases, they almost always had contracts, which were just sort of discounted as not being particularly important. Now, since they're presenting, clubs are now presenting this choice, like between W-2 employment and contract employment. I guess there's maybe an argument that they might take those contracts to have a little more weight, but they're really just one thing in a series of many other factors. And I think in general, even with that choice, when you have all the other factors, like you're going to the club, they're controlling certain elements of what you're doing when you're there, how much money you can make. Those things are going to be way more important at the end of the day. So it probably doesn't make a huge difference which one of those forms you sign for the purposes of proving that you're an employee at some point. I think the other thing to remember is that these relationships between employees and employers, or the hiring party and the worker, if you don't want to take sides on this debate, these relationships are kind of fluid. You can start out as a legitimate independent contractor where maybe the club doesn't tell you anything about when you need to be there, or like just lets you show up and work occasionally, and then you disappear for 6 months and like nobody says anything. Or maybe they don't, they tell you they've got 5 clubs around town, you can just show up at whichever one you want to, or something like that. I mean, I don't know, there could be a situation like that, but then after a year or two, they decide, well, we really want you to come to this one club, and it's only going to be Friday, Saturday night, and it's only going to be these hours, and here's the way we're going to do the payouts or whatever it might be. And then you can move from a contractor relationship into an employment relationship, and that can happen just by the way that the employer might impose new rules or change the way things are being done.
So I want to stop right here and maybe give a little bit of context to people who are not in the industry and watching this, thinking about getting in the industry, or who have been in the industry and have heard a lot of pros or a lot of cons about either one of these. Because right now you're painting a very sort of neutral picture. But I think on the ground, for individuals, it can look, you can have some very strong beliefs about these two. And then I want to sort of explain how these are being viewed, in some generic terms. I'm sure everyone has their own opinion, and then get into a case sample of this, which is what's going on in California right now.
Okay.
So I want to start with what these two categories have been seen as. I think the way most of us in the industry have heard of the terms W-2 or 1099 usually comes from these lawsuits. And the understanding of these class action lawsuits are something like, well, I've been working at this club for X amount of years, and I heard that this dancer at this club, or this group of dancers at this club, they put in a lawsuit, and now they're getting paid out millions of dollars because they are getting their back wages, right? So even entertainers that want to stay contractors because they like to be able to move and to go between clubs, what we hear is this perception of you can show up, and I think it's also fed into by a lot of attorneys that are contacting dancers and putting out this story of, hey, did you hear that the girls at Onyx or at Magic City, they sued and they got X amount of millions of dollars. So I want to get into a little bit of like why the payout sounds so big, and then what the reality of it is, because my understanding is that no one's just cutting out checks for millions of dollars to individuals, but it seems like the way you hear about these lawsuits is these big, massive numbers. And then it's never really about the finer points of whether you are a contractor or an employee, as much as, hey, here's another opportunity to maybe hit the clubs where it hurts them.
Yeah. So, and those are, I'm glad that you provided the kind of, background on the perception of how these things, seem to be maybe trickling through the, I guess the grapevine or whatever. But I guess from what I know about it, to kind of back up and like, I guess, walk through like where the value comes from and all that stuff. So the idea behind the lawsuits, and they're generally brought as collective actions and not as individual actions. And that means that, usually it's an individual, and then maybe a few other people will start a case. In the world of the wage laws, the procedure generally allows the the people that bring the case to distribute a notice to other dancers who might also work for that company and be in the same situation or have the same kind of claim. And then the cases ordinarily, they can join that claim, and then the cases ordinarily proceed as collective action. So it's not uncommon to see a dancer case where there might be lots of dancers in that case. The claims that they're seeking to the claims they're pursuing are going to go back 2 or 3 years in most cases, in some states longer. And the basic claim is that for every hour that they've been working at a club, they've received no direct wages from the club at all. And so when you look at if you've got 50 or 100 or more people in a case, you're talking about multiple years. And for regular hours under 40, the minimum wage is $7.25. So you can imagine that the amount of money that they're seeking goes up pretty quickly. And so in order to resolve a claim like that, whether it's by settlement or by judgment, they tend to be, if they are big groups of people, they tend to be cases that, are large dollar amounts. Now, at the end of the day, the amount of money that each dancer might get out of a case like that would depend on the circumstances of the case. But if you're thinking about what it might mean for you, I mean, you can do sort of a basic calculation and figure out, well, look, if so they've been paying me minimum wage for all the hours I put in over the past year, 2 years, 3 years, what would that come out to? Also, the federal law that governs this permits recovery of both the unpaid wages and an equal amount in what are called liquidated damages. And so that means you get sort of double back pay. And so that also accounts for some of the big numbers that you see, where you might have 20 or 50 or 100 dancers seeking unpaid wages. So they're looking for unpaid wages times 2 in most cases. And then on top of that, there's the attorney's fees that get lumped into that, because those are also recoverable. And so sometimes when you see these settlements, it's not just the back wages that have been negotiated and the double damages, but it's also whatever the cost of the attorney's fees was. And sometimes that can be even more than the damages amount. So, it's important to kind of, like, if you're hearing about these things, it's important to kind of unpack what all those details are, and to sort of get to the bottom of, okay, like, if an individual joined one of these cases, it's not that there's going to be some, there's going to be some $1 million payout at the end, and then you're going to get some big piece of that. I mean, your damages in these cases are always going to be based on what are the hours you worked, and were you owed wages, and if so, those would most likely be paid out in these cases at a rate of $7.25 an hour, or the time and a half for hours over 40. So that should give sort of a better sense of like what a claim might be worth. I think
And
that was kind of the first part of your question. I don't know if I got to the rest of it.
and because you've dealt with some of these cases on the ground and seen how clubs interact with dancers when you do them, I think you have like a very unique perspective on the actual consequences for individuals going through these lawsuits. Again, this is the point of this, is not to take a side or say this is right or this is wrong. I want to provide as much information from all the angles as possible. But one of the questions I think people struggle with a lot is what happens once you start a lawsuit? And I think in theory, I think that we've talked about this before, that there are legal protections when you're going into one of these lawsuits. If you are an employee, right, that you are allowed to tell your employer, that you should be allowed to group and have these conversations. But in reality, when you deal with these cases, what have been the consequences for entertainers? And is that something that good legal counsel can protect them against? Or is that something they have to be ready for? Like, might you lose your job? Might you have to go look for employment at another club? Might you get blacklisted? What are the
so the short answer to your question is yes. I mean, there are protections for people who are engaged in these lawsuits. Once you assert a claim like this, the statutes that govern this stuff will protect you against retaliation. So that means if you get fired, for example, um, you can go to the judge and ask for, an injunction, and have the club the judge can order the club to put you back to work, basically. That's totally possible. The and I should say this too. The vast majority of cases that I've seen, um, you know, uh, there's not a lot of like active retaliation in the sense that people are just getting fired or blacklisted or something like that. The cases I'm aware of where that's happened, the courts have come down pretty firmly on the clubs in those situations. So, you know, sort of on the, for the reality is that there might be kind of other more subtle ways that clubs try to pressure dancers that participate in these cases, and it might be um, you know it can be all kinds of things, but um, sometimes it's through the litigation. So sometimes it's just making the discovery process difficult. Sometimes it's by just being you know just kind of changing the way they treat them at the club, and it's not necessarily like you know costing money, or but it might just make things kind of unpleasant. It just if you're in an active case against your employer, sometimes it's not the happiest place to go to work every day, and that's not necessarily retaliatory. I mean, it can rise to that level, but certainly the I wouldn't expect the situation to just sort of remain exactly the same as it had been once one of these cases starts. So yeah, I mean, there's always a risk that the employer will act in a way that's retaliatory, that it is illegal to do that, and there are remedies that you can pursue for that. At the same time, there's there's a I guess there's a limit to the law is kind of a blunt instrument, and so sometimes you've got to be able to to prove what's happening. You've got to show that it's causing you damage, and that can be a challenge. So yeah, I think in general, like, a good attorney can help you navigate that situation. It can protect you for the most part, but I am aware of situations where it's been very difficult to um, where clubs have acted in that way. I think the other side of this is not necessarily what happens at work. I mean, that's obviously, like, once a lawsuit is started, what goes on at the club kind of tends to be a little bit under a microscope. But the other thing that happens is you've got to participate in the case. So if you join one of these cases, you got to show up. You got to come to your lawyer's office and have meetings. You got to provide documents if those are requested. Sometimes it's things like financial information, or tax documents or something like that. And you've got to provide those, or there can be consequences. So you have to participate in general. Um, and then if the case goes on long enough, you might have to testify. You might have to sit for a deposition or something like that. Good lawyers will prepare people for those situations every day. I don't think it's anything to be afraid of. But it's not like you just send in a form and then you wait for your check. I mean, with these cases, generally speaking, you're affirmatively joining the case as a plaintiff. You're agreeing to participate on some level, and you have to stay engaged, and to not just for because you're required to, but also because you want to keep an eye on what's going on and make sure you understand the case and what's happening in it, because it's ultimately it's your claim. So yeah, I mean, there's a certain amount of effort that tends to go into them. Uh, and then the flip side of that discovery process is that the club's attorneys can sometimes make that more they can try to put pressure on the dancers to settle, I suppose, by taking depositions and serving lots of document requests and trying to make the case a lot of work for the both the plaintiffs and their lawyers. And sometimes case drags on long enough, they make enough of those requests, and people kind of get tired of them and lose interest, and that's a real strategy that happens. So that's the kind of stuff that you see. You know, these cases became so pervasive, I think, in a lot of places, and there were so many of them that the kind of bad behavior, retaliatory behavior that you might have seen, maybe 10 years ago, I don't think is quite as likely, and as seems to be sort of, it's less aggressive for sure. The
And
clubs seem to recognize, they have to behave themselves.
yeah, and
But
definitely working on
yeah,
the other side of that. And to be very clear, I work in a very small, tiny portion of the market, right?
uh-huh,
I only know what I know, but
sure,
um, from the clubs I've worked at and from the clubs that have gone through this process, it seems like these lawsuits have uh, created, maybe in an unintended way, uh, a lot more leeway by clubs and a lot more awareness that they have to keep their dancers happy, right?
right,
Even if this specific club hasn't gone through one of those lawsuits, I have seen, if an area gets hit with a lot of these, a lot of times you'll see more flexibility in your hours. You'll start to
sure,
see more options in contracts, and you'll start to see management sort of trying to do a better job keeping their entertainers happy, because they know unhappy entertainers often reach out to an attorney, like you said, whether it's because of their wages per hour, or it's a harassment
hmm,
situation, or it's
yeah,
a lot of those things. Not to downplay that those things aren't happening, because they are happening in the industry, and they're happening whether you're 1099, W-2,
sure,
whatever. It's like any other industry, right? Like employment law isn't just for us. Obviously, every industry has
yep,
has
right,
its ugly and frustrating and dark sides. But yeah, just a little bit of perspective that it has definitely changed a lot of the hiring processes, a lot of the firing processes, and you can see the effect that
yeah.
these things are having. So now I want to switch gears. And how are you doing on time? Are you good? Do you have about another 30
Um,
for me?
yeah, I've got another like 10 minutes here.
Okay, perfect.
Is that all right?
Um,
Yeah.
so now I want to switch gears and talk a little bit about a situation that's going on in California. It's really unique because it's the first place where the way that we're classified has changed throughout the whole state. So now if
Hmm.
you work as a dancer in California, instead of for it to be possible for you to be 1099, you are automatically a W-2. You are an employee of the clubs. The legal
Hmm.
reasoning for this is a little bit long and complicated, so I'm going to go ahead and post an article below if y'all want to read more
Okay.
about it. But in practice, what this has meant, I think what a lot of folks thought it might mean is that clubs would start to give us things like access to healthcare, and they would provide a lot more of those protections and make sure we have our wages and our tips. And what's been happening on the ground is that the clubs have been figuring out basically creative ways for entertainers to pay for the brunt of these changes. So some of the things that have been happening are uh, entertainers are being put on part-time schedules so that employers don't have to treat them as full-time. Uh, Dancers have been getting a lot less of the cut of their earnings. So where before you might have taken home 700 out of $1,000 earned, now you might only start to see money after you've made the club $200. And then at that point, you might start seeing percentages of what you make that you're able to
Mm,
keep. And on top of that, the club is obviously taking out all of the taxes, and they're also finding ways to charge entertainers for VIP rooms, for basically anything under the
mm,
sun that you can be charged for. They're looking for ways to close the gap between what they have to pay out and what dancers used to be covering.
mm,
So understandably, a lot of people are really upset about this. There are
sure.
unionization efforts that are starting in California. There's also been a lot of dancers that have just been leaving the state because they're
Right.
understandably very frustrated at this. I wanted to see if you have some insight onto what options people have when they're undergoing a change like this, and how they can talk to their clubs in a way that is um, effective and that helps them be heard when they're being hit.
Yeah. Yeah. So this is a real challenge. I mean, I think the industry is like gonna have to, they're gonna have a sort of reckoning like this where, um, you know, but clubs try to figure out what they're willing to do in terms of the compensation structure, and I think dancers have to figure out what they're willing to accept in terms of their pay. Um, you know, Sitting where I am, I can imagine lots of different ways to pay to pay dancers. I mean, certainly there's already, and you can look at this as sort of like there's already a system in place for people that receive, customer gratuities and tips, right? So there's already an entire, legal framework for how tipped employees are paid. Um, and certainly there are rules about that. Um, there's pros and cons to being somebody that's a tipped employee as opposed to somebody who's paid hourly. Um, and so there's probably lots of different ways that the situation can be addressed. I think at the end of the day, um, particularly in a place like California, there there are good things about being an employee. There should be, I would expect that there should be some bargaining power there, and whether that means um, getting together and trying to bargain, maybe as a doing a unionization effort or something like that, or even just getting together as a group and just trying to negotiate um, you know agreements on how wages will be paid. I mean, all that stuff is possible. Um, so I think the important thing to think about here is that the from the dancers' perspective, the clubs need the dancers to be there in order to function, and that means that you have some bargaining power. And I think just like any other job, um, when you show up, I don't think it's unreasonable to to make offers and receive counter offers from the club and try to negotiate how it's going to work. And then whether you want to be a tipped employee that gets to retain your tips and then paid some sort of sub minimum direct wage, like the way servers get paid or something like that, or whether you want to negotiate some other kind of arrangement with your employer. Whatever you decide to do, I think it's important to try to get these things reduced to writing and to come up with an agreement, so that it's just because you're not a contractor anymore doesn't mean you can't have an employment contract to work for somebody. And so you can negotiate with the employer. It may not seem that realistic because of the history of the industry. I mean, in the past, my understanding is that the clubs have really kind of just dictated the terms of what they're willing to do. But I think the challenge is going to be that if they can't make the employment situation workable for the dancers will leave, as they have been in California. And then now the clubs have to come to the bargaining table, I think. So overall, I think there's going to be hopefully there'll be some real arm's length negotiation between dancers and club owners in the future, so that you can actually work out something that makes sense for everybody. But the clubs are starting it from a place historically where they shifted a lot of costs onto dancers that shouldn't have been, and they avoided really having to take responsibility for the revenue that came through the clubs by having so many contractor workers. And so the financial consequences are extremely different now for the clubs, and that's something to kind of recognize, is that they're trying to figure this out too. But yeah, I think certainly there's lots of different ways. I mean, it's worth trying to figure out what the club's willing to do, and then I think it's always worth talking to somebody, whether if you've got a group of people together that want to go and consult a lawyer and ask, hey, is this a fair way to be paid, or should we ask for something else? Or if there's a unionization effort. I mean, all those things are worth, I think, considering when you're trying to navigate the situation. But I think it's we're in a period now where it's just changing, and I think it's sort of an open question, like what the best way to work these deals out is going to be.
So I have two last questions for you, both to sort of round this out. So that sounds really good, right? You can have some of these employee rights, and then you're also having power to negotiate and speak to the clubs and be heard. And have a say in how our employment goes down. But I think a lot of what's going on right now is because, the demographic of entertainers is generally pretty young, and
Mm-hmm.
maybe not a lot of us have experience with this. I think one of the hardest things would be to figure out where you can get information about this, where you can get a little bit more educated, so these terms don't sound so challenging, and
Yeah.
to get maybe a little bit of background on how negotiations like this have gone on for other groups that went through this process. So if someone wanted to do some self-education, what are some
Mm-hmm.
resources or places they could start to learn about these differences, to learn about the unionization process, to learn about
Yeah.
collective bargaining?
Yeah, I mean, certainly, I mean, look, there's obviously just, an endless amount of information on the internet, but I think that um, you know, I think that some of the best information you can get is going to come from people in other industries. So if you know people that work for corporations, or if you know people that work, as tipped employees for restaurants, talk to those people, find out, what the hiring process was like, what they're responsible for, in terms of their job duties and schedules, talk, and then compare what you're getting and what the offers are coming back to you with what these folks are getting, and ask them whether they negotiated their salaries or they negotiated the terms of their employee tip pool at the restaurant they're working at, and how those negotiations went, and like what they asked for and what they ended up with. um, you know it's while it's there are there's certainly plenty of sites out there, and lots of lawyers have good blogs about, there's an FLSA overtime blog, and there's all kinds of good stuff out there about these, that provides information. Certainly, the National Employment Lawyers Association has a page with a lot of good information on it. Um, the best information about how negotiations work and how to get the best deal for yourself possible, the best information is going to be from people who've done it before. And so you're going to have to kind of go through your phone book and look at your contacts list and think about, okay, who do I know that has you know that may have negotiated their own salary, or the terms of their employment, or who do I know that might have an employment contract. And then, if all else fails, it's worth going and talking to an attorney. If a lot of attorneys will do sort of initial consultations, and give you an idea of what it might cost to strategize and negotiate something. But I imagine that's probably for those that are more established in the industry. For people that are just starting out, I would think that friends and family and talking to people in other industries, because when you're an employee trying to navigate your first job or second job or something like that, I mean, I think in the end this is really going to end up looking a lot like what you might consider to be sort of a traditional employment relationship. And I think the expectation is usually that there is some negotiation that happens. And so I'd talk to people that have experience doing that, and find out what their experience was like.
And last question, you
Mhm.
pointed at this too. You said, people in other industries and who've done it before, obviously lawyers in the employment world have probably seen a lot of different versions of this play out.
Yeah.
And you mentioned if you were in the stages of unionizing or collective bargaining, that might be a place to go to for advice. So on that note, can we close out with just a little bit of guidance from someone in the industry of, if you're looking for an attorney to help with this, if you're looking for advice, what kind of
Mhm.
things should you be looking for in an attorney? And what might be some red flags about someone who's not well suited to do this kind of work with us and with the community?
Yeah. So I think, well, certainly there, sort of lawyers break down into lots of different categories. There are people that are, more active litigators. That means they're going to be, interested in filing lawsuits or defending lawsuits. And then there's lawyers that are more transactional in nature, that are more interested in deal making. Um, it's hard to find lawyers in the employment world that are doing more of that transactional work, that because it's less common. But there are lawyers that specialize in labor and union issues. There are lawyers that specialize in employment contracts. There are certainly lawyers that specialize in wage and hour issues. But I think the thing you want to be looking for is specialization. You want to, lawyers tend to have a field of expertise that's very specific. And so you want to find somebody that does this kind of work, as opposed to your, you know, criminal defense attorney or your family lawyer or whatever else. So, you're looking for somebody that does employment work. And then I think you want to be clear, in this context, what you're talking about is negotiating the terms of employment and or whether it's a contract or just getting the right offer, and that you're looking for advice on that. And that's a very different thing than signing up to be part of a lawsuit. And so, you know, I would probably, if I were hiring a lawyer to represent me to go and negotiate something about my employment, I would probably look for somebody that, has represented other lawyers in employment contract negotiations before, and that, has a reasonable hourly rate, or would maybe do the work on a flat fee. Sometimes lawyers will do things like on a fixed, basis, and try to get a sense of what it's going to cost to, evaluate the situation and get some advice. I think for things like this, it's, for most experienced employment lawyers, it shouldn't take a lot of time to listen to somebody and figure out, what a good outcome would be or what a good contract might look like. So I don't think these are like, outrageously expensive consultations that you're talking about. So I think it's totally doable. It's probably not, everybody's first call. It's like, I'm going to go get a new job. Like, let me call a lawyer. But it's actually really worth doing if you can do it. So, and like I said, I think, there's also, if there are other people that are doing the same thing, get together with them, and maybe, maybe approach somebody that, a lawyer that's got some experience that might be willing to do something for the group. And maybe that can make it more cost effective.
Sweet. Thank you. All that was super, super useful. Is there anything else that you can think about in this area? Any other advice? Any other information? Well, not advice. We're not giving legal advice.
Not advice. Yeah.
Not advice.
Yeah.
Information. Any other information that
this has felt very comprehensive to me. I've been like kind of going back through my memory on all this stuff, but no, and if you've got any other questions for me, feel free to email me and ask. I'd be happy to try to answer them.
Awesome. Thank you so much, Don. I appreciate you.
Yeah. No, thank you.